Hi, I'm Stanley Goldberg, host of the Inquiring Mind podcast. I hope you enjoyed today's episode. And if you're new here, I release 2 episodes a week with a variety of fascinating guests, and I would appreciate if you would support my podcast by liking this video and subscribing down below. Thank you for your support, and now to today's. Judge Newman, welcome to the Inquiring Mind podcast. I really appreciate you coming onto the podcast and speaking with me. I'm an aspiring lawyer myself. I'm not in law school yet. I'm still studying to get into law school, but it's always interesting to get to discuss ideas with people that are successful in their field. And obviously, you're very successful in your field. So let's just start with that. How did you first get interested in the law?
I'm not exactly sure. My father was a lawyer, but I didn't really expect to practice law. I think when I was in college, what I was interested in was government service, public service of some form. I wasn't sure what it would be. And I thought a law degree was probably a useful both credential and entree into fields of government service that might open up for me, and that turned out to be true. So it was more a question of government service than the practice of law. I often kid that for me, the practice of law was the employment of last resort. It's turned out I did practice off and on for 6 years in different, but most of my career has been in public life.
Mm-hmm. And did you ever think about if you didn't become a lawyer or a judge, what it is that you would do?
I don't think I've really spent much time on that topic. I suppose it's not too late to think about it now. I don't know. It would have had some public characteristic somewhere in either state or federal government.
Hmm. What was it about federal government and about, I don't know, maybe the realm of politics that interested you so much?
Well, it seemed useful. It seemed interesting. You could make an adequate living. I wasn't terribly interested in making a huge amount of money, but I did want to make a living. I do something. But public service just seemed to me a useful way to spend one's life.
Hmm. Okay. Um, and if why weren't you too concerned with, making a lot of money going to the private sector? Why was that not a major concern? You ever thought about that?
No, I don't know why. I needed to work. And needed some sort of salary, but I didn't aspire to own a yacht or uh, a huge mansion or anything. I just wanted to be employed and do something that I enjoyed and that I thought was useful.
Hmm. And when you became a judge, how would you say that experience has changed over the time that you've been on the court, from when you first started being a judge to now? Has the experience changed at all or no?
Oh, I'm sure it has changed somewhat, although I doubt if I'm the one to assess that. Self-evaluation is usually not very accurate. Um, you gain experience, obviously, the longer you do it. I started on a district court where I was for 7 years, and I've now been on a federal appellate court for 42. And I'm sure I've learned a lot of things. I would hope I do the job better today than I did when I started. But again, it's not really for me to say. But essentially, I'm not aware of significant differences. The district court, I certainly learned a lot in the first year. Nothing quite prepares you for being a trial judge. Once you get on a court of appeals, having been a trial judge, you know a good bit about it going in. But there are always things to learn, and there are always new fields of law that come to you that you don't know anything about. That's what makes the job very interesting. So you'll learn a lot, and hopefully you continue to do a better job.
And so what kind of fields of law did you find maybe most interesting when you first encountered them?
There were two. On the Court of Appeals, I became very interested in field that is known as intellectual property, sort of a fancy title, but it covers things like copyrights, patents, and trademarks. And since the court I'm on is in New York City, home of a lot of publishers and artists and performers, we tend to get a lot of copyright cases, and I found them very interesting. And I ended up writing quite a number of copyright cases. I'm also very interested in a very technical field called federal jurisdiction, deciding whether a case belongs in a federal court as distinguished from a state court. Those are often somewhat difficult questions. If we had a unitary system like some foreign countries, we'd never encounter them, but we're a federal system. And there are state courts and federal courts. And often one of the hardest questions in the case is not who wins, but does it belong in state court or federal court? And I find those interesting. They're technical questions and I enjoy working through them.
Well, what factors go into whether a case goes into a federal court or a state court?
Well, you're generally dealing almost always with an act of Congress that gives the federal court certain jurisdiction. We're not, in other words, in a state court, you don't have this problem. The state court is a court of general jurisdiction, and they have all civil cases, all criminal cases, unless Congress has said, no, you, the state court, don't get that case. It belongs only in federal court. With us, it's always a question of looking at a statute to see if the statute gives us the obligation to hear the case. Usually that's fairly clear, but there are some cases, some statutes that are not clear. And so it's sometimes a close question. Does this case really fit under the statute and belong in a federal court?
Mm-hmm. As a person that's been doing this job for close to 50 years, am I correct in saying that?
Pretty close.
What keeps you going? What makes you, as they say, waking up and putting one foot in front of the other and going to do your job? What motivates you?
I would say the fact that the cases continue to be interesting. I find something that is either not so much a new field, but a new little variant on a field, a new twist. And it's always interesting in anything you do to come across a new problem and grapple with it. And without being too presumptuous, I really think after doing this for a great number of years, the public has a sort of an investment in me. They've given me the opportunity to do it. They've provided that opportunity. I've learned a lot. And so I think as long as I'm physically and mentally able to continue, I should continue. And so I do.
Obviously, I think a lot of people hate hearing this maybe, but you're 89 years old, correct?
That's correct.
Yes. You're very sharp and you're very, you're in good shape. How do you, what do you do to keep in, like good mental and physical shape to be able to keep doing your job?
The physical part is easier. I continue to play tennis and I play golf. Those are not huge exertions, but they're better than sitting on a couch.
Tennis is tough.
Tennis is the tougher of the two. I don't jog. I don't work out. My wife and I live half a year in New York City, so we walk a bit. And in our New York apartment, there are stairs. So physically, I get around. The mental side of it, again, is sort of not for me to say. What I've done, which we're encouraged to do, and many judges have done it, I have paired up with another judge on my court and said, look, if you get the sense that I'm beginning to lose it, I want you to come tell me, and I'll do the same for you. Usually in the judiciary, your family becomes aware if you are really not up to it. And there's actually a procedure to relieve a judge of duties and put him on senior status or disability status, actually, if he really is not up to the job anymore. But usually judges, either themselves or their families or their colleagues, become aware of that at the appropriate time, and it's not a problem.
And do people have the courage to come up to you and say that if you know if that does happen? Do you think?
Well, as of yet, I don't know because no one has said that to me. There's a famous anecdote that somebody came to Justice Holmes when he was rather elderly and told him it was time to quit, and he resented the overture quite a bit. He eventually agreed to it. But generally, it works out, and I don't think there have been problems where a very elderly judge was beginning to lose it. But as I say, either his family or his colleagues spoke up, and he then took senior status or retired from the bench entirely.
I don't want to stir up too much controversy, but by asking this question, but do you see yourself not doing this job that you're doing eventually while you're, you're still in good shape and sharp? Do you see yourself saying, you know what, I'm going to step away?
I think that's highly unlikely. As long as I'm mentally able to do it, at this stage, I don't want to sort of go off and just work for a law firm or teach or a foundation or something like that. No, I think I've been doing this a long time. I should continue doing this. At my age, you don't plan too far ahead. So it's sort of year to year. And I think I'll do it as long as I'm able to.
Have you ever taught?
Oh, yes, I have.
Oh, where'd you teach?
I've taught at the University of Connecticut Law School. I've given courses. I've given classes at the Yale Law School. Gave a seminar at the University of Hawaii. I think those are the major ones. And then in the era of Zoom, I've been able to hold conversations with law students at other schools. Oh, and also I was a jurist in residence at Duke and at the University of Southern California. But the main full course teaching was always at the University of Connecticut Law School.
Did you enjoy it?
I did, yes. It's an added task, particularly at exam time. It's no fun reading and grading exams, but I did enjoy the interaction with the students. So in the later years, I've sort of just done a class. I do visiting classes at Yale mostly, and occasionally other places, and then these 1 or 2 week stints, usually 1 week stints at a law school like Duke.
Have you noticed how law schools have changed from the time when you went to the current day?
The most observable change, of course, is that women are in the school in great numbers. When I was at law school, I graduated in 1956. There were only 4 women in my class. And now when I teach a class, I look out there, it's about 50-50, sometimes maybe a few more than 50-50 on the women's side. That's the main thing you see. And also minority representation. There was, I think, what do we have? Maybe 1 or 2 African-American students in our entire law school class. And so as you look out at the class now, you see African-Americans, Latinos, Asians. So it's diversified by gender and ethnicity. That's the main thing you notice when you're teaching a class today.
Have you seen the quality either decline or increase?
I don't think so. I think the law schools, the front rank law schools have always had a pretty rigorous admission policy. I do notice when I look at the credentials of the people applying to me as law clerks, these are usually men and women either right out of law school or after they clerked at a district court, they apply to a court of appeals. I am impressed that their credentials are just awesome. They're more sophisticated. Their experience is wider than my classmates were back in 1956. They're PhDs, or they've worked 2 years abroad, or they've been working in different areas, studying interesting things, accomplishing interesting things. They just have a fuller resume any of the people I was in law school with, including myself.
Mm. And do you, again, wishful thinking, but do you, how does one get to clerk for you?
You apply. Uh,
Oh,
the,
yes, but
well, really, I don't mean. I mean, that's what the federal judiciary has a website, and every judge lists the criteria that they use in selecting law clerks, and then people who want to apply to that judge or several judges look on that website, and then they decide to apply. When I was an active judge, which I got to explain, in the federal system, at a certain age, a number of years, you can elect to become a senior judge. That means you're still a judge, you still decide cases, but you can reduce your workload. And I have elected to reduce my workload quite a bit. But so with the clerkship issue, when I was a active judge, as they call it, I probably got about 350 applications a year for 2 positions. So, and this was a very good group of candidates, and I would rather quickly, from their credentials and their law schools, frankly, winnow it down to see who were the ones from the top law schools and their top students at the top law schools, and then interview a small number. I never interviewed a lot, and I only took 2. I was allowed 3 or 4, but I preferred 2. And I would bring in maybe 5 or 6 for an interview and then make my selections. It's pretty, as I used to say to them, it's the most arbitrary decision I made all year, because they're all good. And you just have to decide which 2 of the 5 or 6 you're going to spend a year with.
How seriously do you consider what law school somebody attended?
In deciding to hire a clerk?
Yeah.
Well, it does matter, and I'll make a confession. For many years, I took clerks only from the Yale and Harvard law schools, mainly because I just didn't have time to sift through 100 applications from 20 law schools. Mm-hmm. And if I ever had to do it over again, what I would have done is kept it at 2 law schools, but picked 2 different law schools every year. So I think I was too confining to use Yale and Harvard. I think that was a mistake. But I would have limited to the front rank law schools, because they are getting the front rank students. Now, that doesn't mean somebody at a school that I never heard of isn't a very, very bright man or woman. They may be, but I don't know that. And so if they get into Harvard, Yale, Columbia, Stanford, Chicago, I know right away they have very good high school and college credentials. Mm-hmm. So they sort of sift for me. And since I don't have time to read hundreds of applications, I let the law schools do it for me. But to answer your question directly, yes, I do think that the front rank law schools are enrolling, on average, the top students. But as I say, that doesn't mean a student at some other law school. When I taught at the University of Hawaii for a seminar, I had a wonderful group of students. And I'm sure they could have done the clerkship job with me just fine. But I don't know that. Whereas if they get into Stanford or Columbia or Yale or Harvard, that right away tells me that they are highly qualified young men and women.
That's fair. But from what I gather, and I've spoken to a lot of people at different law schools, the level of education is very similar across the board.
You mean the content?
Yeah, the content.
Yes, it is similar. Yeah.
So if somebody has I'm playing devil's advocate, but like if somebody has a 4.0 in a school you might not know, and a 4.0 at Harvard, is there really a difference between the 2?
There may not be. There may not be, but I have a sort of a higher degree of assurance. Mm-hmm. With the one who has the top grades at Harvard. Not so much the grades. What I'm really interested in, what's their law review experience? Are they on a law review? Are they one of the editors of a law review? Because that means they have spent a year and a half, maybe 2 years, doing the kind of work I want them to do for me as a law clerk. They are writing and they are editing. So it isn't so much grade point average as it is law review experience.
Oh, that's interesting. I once heard I was listening to a podcast with Malcolm Gladwell, who's a famous like pop psychology writer,
Yes, I
and
know.
yeah, and he had a couple of episodes about the LSAT, which is the admissions test to law school, and one of the interesting things, he introduced the podcast by showing a conversation that uh, the late Justice Scalia had at American University in I think it's in DC. And this one young lady, law student, got up and said, well, essentially, do I have a shot at being your clerk? And he all but said no in a very nice and respectful manner. But he then turns around and says, in the next sentence, he says, well, my best and favorite probably clerk is a guy named Jeffrey Sutton, who attended Ohio State University Law School.
Yes, I
Well,
know.
yeah, and I found that extremely interesting from then on. Like, why this, in spite of the fact that he knew that his best law clerk was from a school that's not within the top 15, as far as I'm concerned, he still picked exclusively from Harvard. That's why I'm maybe pressing you a little bit on the issue because it's interesting.
I can, obviously, I've never asked Justice Scalia why he picked Jeff Sutton, but I can guess, and it's a pretty educated guess. And my guess is because when Jeff Sutton got out of law school, he got a Court of Appeals clerkship, maybe a district court and Court of Appeals. And my guess is he did very well with the Court of Appeals judge who Justice Scalia knew and respected. And that's who recommended him to Justice Scalia. That was, for example, that was my experience. I clerked at the Supreme Court, but it wasn't because I went to the Yale Law School. It was because I had a clerkship with a Court of Appeals judge and was recommended to a Supreme Court member of the Supreme Court to get a clerkship there. So, and I've had that happen. I had a clerk, I think 3 years ago from the Cardozo Law School, which is a good law school, but frankly, I'm prejudiced. I went to Yale. I think Yale and Harvard are by and large a tiny bit better. But he went to a Cardozo Law School. He had a clerkship with a district judge who I knew and respected, who recommended him to me. I took him, and he turned out to be one of my top-ranked clerks.
Wonderful.
So I think you have to crank in where they were before Justice Scalia got them.
Yeah.
In order to make the total assessment.
Fair point. Well, it's good to know people have a shot to be your clerk. Okay, so I want to discuss. I have your book right here, Benched. I really enjoyed it. Some very interesting anecdotes. Actually, a few things made me think a lot about certain legal cases and just interesting stories across the board, which I enjoyed. Let's start with maybe the most controversial one, and you start your book with it, and that's abortion. Can you explain why you started the book with that topic, and why is it still such a controversial topic to this day?
Well, the first part, well, both parts are easy, actually. I started the book with it. I didn't want to just go chronologically and say on page one where I was born. I thought that case, which came to me as really the first important case I had as a district judge, and it came to me, I'd only been on the bench 2 months. So it was a pretty heavy case to arrive on a young 39-year-old judge. And it was not only an abortion case, which made it controversial, it was an abortion case before the Supreme Court had decided Roe against Wade. So the issue was open. The constitutionality of a prohibition on abortion was an open issue to federal judges before the Supreme Court ruled. So its importance was clear. It came to us, in those days, it was called a 3-judge district court. It was, even though I was a district judge at the bottom level of the hierarchy certain cases in those days required a panel of two district judges and one circuit judge. And so I was selected to be on that panel. Why was it important? Well, clearly important, highly sensitive issue, highly controversial. Passions were very high. Those who think a woman has either an unfettered right or a somewhat open right to an abortion feel very passionately. And those who feel that she does not have a right, that the state has a right to either prohibit or limit it, feel just as passionately. So you rarely get a case where the emotions are that high. And at least before Roe against Wade, the law was that unclear. So all those factors combined to make it a very important case for a young 39-year-old judge.
Yeah, I can imagine. When I was reading the book, I was actually I tried to put myself in your shoes, and I feel like I'd be extremely nervous to.
Oh, you say, why did I put it at the beginning of the book? I did that because my guess is, although I've written, I think it's what, 1,300 opinions, maybe more now. My guess is it probably is thought of as the most significant opinion I ever wrote, even though it was just about the first. I've written many others. Many of them I think are very important. But my guess is that people who know anything about me probably still regard that as an important opinion because it's been written about, it was cited by the Supreme Court in Roe against Wade. It was referred to in the memoranda that some of the justices exchanged as they considered it. I have no claim or illusion that it affected how they came out. I would never claim that. I do think it put in the mind of at least Justice Powell and maybe some others the thought that what was a critical event in the evolution of a fetus was viability, and that the state's interest, as I wrote in my opinion, the state's interest in limiting abortion was pretty significant before the fetus could survive outside the womb, but was far less afterwards. And that found its way into the Supreme Court opinion a little bit in Roe and much more in the Casey case years later. For all those reasons, it's important. It was important in my life, and so I thought I should begin the book with it.
Yeah, and in a case like that, and in pretty much any case, how do you balance maybe your personal opinion on the subject and then your judicial responsibility when approaching the case?
Well, I've always thought that it is not a balance between those two. I don't put my personal view on one side of the scale and what I think the legal values are on the other side and weigh them. I try as hard as I can not to let my personal views influence at all. I have many cases where I have sustained an act of Congress that I thought was absolutely stupid, that I would have personally voted against it if I'd been in Congress, but I thought the Constitution said it was constitutional, and the converse. I struck down a couple of statutes that I thought were unconstitutional. I mean, I struck down, I voted that they are unconstitutional, but had I been in Congress, I would have voted for them. My personal view would have been for them. So I try very hard not to say my personal view of whether it's a good law or bad law, or a good plaintiff or a bad plaintiff, or a good result or a bad result. Influences. Now, at the same time, who we are, where we came from, what our philosophies are, what our education, what our whole upbringing, all that goes into who we are. We're not fungible, and we come out differently on different issues. And in the Supreme Court, you see them voting 5-4, 6-3. We're different, but I think there is a difference between coming out differently on legal and statutory and constitutional issues and just giving way to your own personal preference. And I think when the Supreme Court votes 6-3, they are not just saying, oh, do I like this result or not? I don't think they're doing that. I know they're accused of that all the time, usually by the people who don't like the outcome. It's the same with the labels activist and restrained. An activist judge is one who decided the case she didn't like the way it came out. And so when I decide a case and somebody doesn't like it, they say, well, you're activist. And then if I come out the way they like, they say, oh, that was a marvelous example of judicial restraint. The labels I tend to put aside, but the more serious point is that all of us, I think, really try not to just say, who do we like in this case? What personal view do we get? Now, does a personal view enter subconsciously? It may. If it's subconscious, I don't know about it. That's why we call it subconscious. But at least we try to simply approach each case as a legal matter. And if it's constitutional, we have a lot of constitutional law to look at. If it's statutory, we've got to figure out what did Congress really mean by this statute. Sometimes it's perfectly clear, sometimes it's not clear. They often use sentences or words or phrases that are not clear. I don't criticize them for that. When I worked on the Hill for a senator, it was part of my job some days to find words that were unclear so that we could get the amendment passed. So I understand that in the political process, words or phrases in a statute will not be clear. And in that case, the court can't just say, well, it's not clear, we're not going to decide the case. It's got to come out one way or the other. And you got two sides in front of you saying what they think the statute means, and you do your best to interpret it, starting with the text, as we always do. But if the words aren't clear, then we've got to search for either related statutes, related parts of the statute, legislative history, other sources of indication of what did Congress probably mean by this vague phrase. And of course, if we come up with an answer and the current Congress says, you know, we didn't really mean that, they can always amend it. They're the Congress, that's their job. With the Constitution, different matter, because although it can be amended, that's a hugely complicated process. And so we better get it right. Now, I'm on a court below the Supreme Court. And of course, if the Supreme Court thinks I interpreted the Constitution wrong, they can take the case and decide it differently. Sometimes they affirm me, sometimes they reverse me. Well, that's just the fact that we're in a hierarchical system. I accept that. I have no problem with that at all.
Mhm. And one of the interesting parts of your book was it was a fairly brief chapter, but it was a chapter on being considered for the Supreme Court. And at the time, you said that maybe this was a wrong time to be considered, and you mentioned in the book that in that whole consideration process, you never got a call from the White House, if I'm not mistaken. Why didn't you want to be a Supreme Court justice?
Well, it was a question. Well, first of all, although I said I thought it was unlikely I would have done it had it been offered, I have to admit, you never know for sure on an issue like that until you're put to it. But my inclination at the time, and as I reflected back on it, is I would not have done it because of that time in my life. Had it come when I was, say, 50 years old, 53 years old, 54 years old, I have no doubt I would have done it. But it came to me much later in life. Family circumstances were different. And it just seemed to me it was the wrong time and the wrong conditions to make a move like that. So, and I can be reasonably sure I would have turned it down because I had two senators call me up and say, what can we do to support your possible candidacy? And I told them both, don't get out there on this because I probably would not do it. And they were surprised, but they said, okay. And so I did tell them no. I thought it was surprising the White House never asked me. I don't mean to be presumptuous about it, but the New York Times reported that at one point it was down to Justice Breyer and me. I don't think it was that close, but they said so. And I, years later, asked White House counsel, I said, you know, I'm pretty surprised that if I was on the list. Oh, yes, he said, you were clearly a prime candidate. I said, well, you never called me to find out would I take it. And he said, why should we call you? Every judge wants to be on the Supreme Court. And I said, well, I think maybe you'd have been smarter to make a call and see if I wanted to be on the list. And he laughed. But in any event, that's how it happened. And the Times was wrong. They, as I said in the book, they said it was down to Breyer and me right up until the day when Ruth Ginsburg was appointed.
Is it everyone's dream as a judge to be a Supreme Court justice?
I think it probably crosses the mind of at least all the appellate judges. It's almost, I don't think a district judge thinks lightning's going to strike and he or she is going to go to the Supreme Court from the district court. They hope to get to the Court of Appeals. Once on a Court of Appeals, I think it's fair to say that unless they are well past, let's say, what, 65 or so, maybe even 60, but a judge who's in his or her 40s or young 50s, yes, I think they all have some hope of being on the Supreme Court. Some of them may think it's such a long shot they don't lose much sleep over it. I think it's fair to say there are others who think about it every day. It just depends.
How about for yourself? Had it not been for the life circumstances at the moment, at that time, obviously it's a little bit of a Monday morning quarterbacking, but do you feel like you would have accepted the job?
Oh, sure. If it had come when I was 50 or 53, there's no question I would have accepted it. Yes.
Was that a dream from the moment you got onto the circuit court?
Oh, not a bit. I mean, I think any Court of Appeals judge is crazy if he spends a lot of time hoping lightning's going to strike. The odds are way against you. You have enough to do being a good appellate judge, Court of Appeals judge, and to waste your time worrying about whether someday you might be offered a Supreme Court judgeship, I think is a huge waste of time and a diversion. I think it's just it just shouldn't be part of what you're thinking about. You should be thinking about your work day to day. And if you are 50 or 55 and some administration wants to put you on the Supreme Court, fine. But it's just like any lawyer shouldn't spend their time worrying, are they going to get to be a district judge? Because the odds are against them. It might happen, it might not. And you shouldn't be pining for it. You shouldn't be setting yourself up for a disappointment if you found yourself 65 years old and still a lawyer. Be a good lawyer. Same with being a appellate judge. Be a good appellate judge. Let life take care of itself.
Right. Early in your book, you also talk about clerking for Chief Justice Warren.
Yeah.
And you were his senior law clerk.
Yes,
and
that title doesn't mean a great deal.
Yeah, I know. And one of the responsibilities, what made you a senior law clerk, was deciding who would attend the luncheons, correct? Am I?
That went with the job. Warren took one clerk from the Court of Appeals clerkship and the other two directly out of law school.
Mm-hmm.
And of the three, he has three in those years. The others had two. I can tell you why in a minute if you care. So the one who came from a Court of Appeals, as I did, by virtue of that, became the senior law clerk. And the only consequences of being the senior law clerk were, one, you got a bigger office. The other two had their own office. And as you suggested, you got to invite the guests for the monthly lunches of the 18 clerks. And that was a lot of fun because I never quite understood why, but we had huge drawing power. We never got turned down. We invited some of the justices to the monthly luncheon, but not all of them. And we invited other people. And as I recount in the book, I one day invited the junior senator from Massachusetts, and my clerk colleagues, they gave me a lot of grief about that. They say, why him? He's junior senator. And I said, this guy has a big future. And of course, it was John F. Kennedy.
And what was, and that was actually my next question. Who were some of the most, you would say, impressive people you got to interact with because of these luncheons? And what did you see in John Kennedy a young John Kennedy, that made you believe that he had a political future?
Well, taking the first part, certainly the justices we invited were wonderful luncheon guests. They felt free to talk. They were very candid. They knew we would observe their confidences, and so these were very candid discussions. Beyond the court, in addition to Kennedy, the name that stands out was Dean Acheson. I was astonished he would say yes, but he did. Maybe because he'd been a clerk, I think to Justice Holmes. And he came, and it was a very interesting hour. As far as Kennedy, well, I was very aware of him from being in Connecticut. I grew up in Connecticut and had an awareness of him from Massachusetts, and having my toe in Connecticut politics, I became very aware of him and was very impressed. And of course, he had run for vice president in 1956. And the year we're talking about when I invited him was between 57 and 58. But he came to national prominence mostly in 1956 when he ran for vice president, or contested the vice presidency against Kefauver. Of course, the best thing that ever happened to him was he lost. But that made him well known and the center of attention. People paid attention to him. They listened to him. They heard him speak. He had this interesting youthful exuberance, a lot of style. I thought he inspired people. I thought one of the best things he did was inspire a whole young generation into public service because of who he was and how he conducted himself.
Yeah. I went to a lecture once by famous biographer and historian David McCullough.
Oh, yeah.
And he said that when Jack Kennedy would give those speeches, he inspired a whole generation that would otherwise go to the private sector to go into government. And a lot of people that went to Harvard, Yale, whatever, and probably would have made a lot more money going into the private sector, devoted a few years of their life to go work for their president, right? And in whatever capacity they could. And I think in a lot of ways that I think that's missing today, because there's no one that really inspires younger people to go into government and pursue a career in government. But that's a whole separate story. Do you have luncheons like that with your clerks today?
Oh, sure. Well, it's changed in the era of the COVID pandemic.
Before COVID.
Before COVID, I had lunch with them almost every day. Sure.
How about inviting guests to speak?
No, because it's not a group session. When I say with the clerks, I mean my own clerks, my two. In the Supreme Court, it was a luncheon of the 18 clerks who worked.
Okay.
So it was very different. Now, these were not my lunches. These were, we had a lunchroom then. They don't have one now. It's too bad, because those were interesting conversations among the clerks too. And the 18 clerks would have lunch almost every day in the Supreme Court building. And they would have these invited guests once a month.
Oh, that's great. Another interesting section of your book was when you reviewed your First Amendment, a lot of the prominent First Amendment cases you got to decide or give your opinion on. Two such cases were the Board of Education versus Pico. Am I pronouncing that correct?
Yeah, I've never been sure whether they call it Pico or Pico. I don't know. That was the name of the litigant, and I never met the person, but let's call it Pico. I don't know.
Pico. And Brooklyn Institute of Arts and Sciences versus the City of New York.
Oh, yes.
Why is the First Amendment so often, I guess, under attack? And why is it so difficult to have people support the First Amendment universally?
Well, let me start with your premise. Why is it so often under attack? sometimes it's under attack, and sometimes there's a vigorous defense mounted in support of it.
Mhm.
In fact, I'd like to think the support is often more prevalent than the attack. Now, the defenders of it, of course, are the people who want the widest possible range of free expression, free of government restriction. I don't know that people are actually attacking it when they criticize some decisions. I think what they're saying is that, well, sometimes they are. Sometimes, for example, in the hate speech area, they're saying government should be able to ban or at least punish or restrict hate speech. European countries have gone really far down that road in making it a crime to utter hate speech. In this country, the First Amendment has mostly been a barrier to that type of restriction. Hate crimes, if you commit a crime, a killing, a rape, a robbery, and there may be an enhancement to your sentence because of some hateful things said or expressed in the course of it. But as far as just making a speech in this country for 30 years, we've been very cautious about punishing speech. And the First Amendment is strong, and the interpretations of it, I think, have become stronger over the years. And I personally think that's a good thing. I think that's what the framers had in mind. They probably only had in mind that it would be a limitation on the federal government. But then after the 14th Amendment was adopted, and then a few years after that, the Supreme Court said the First Amendment limits the states as well. It didn't for the first 100 years. But after the Supreme Court said it limits the states, then any state statute or state police officers or other officials' limitation on a speaker became a matter of concern to the federal courts. And so some of them are close questions. Sometimes it's a question of whether what the speaker says has to do with religious liberty. And so those issues are a little different from just straight speech issues. And but then the First Amendment protects religious liberty the same way it protects speech. When I say the same way, I mean in the same amendment. I don't suggest the clauses are identical. So sometimes you're going to find close questions as to whether the person's religious liberty right lets them do something, or whether the government gets to apply some restriction. And the same in the speech area, whether the person, but certainly the First Amendment stands as a distinctive feature of the American experience.
The nice touch, I thought, after the, what do we agree to call it? PICO? PICO?
Yeah. Oh, we didn't get to the case. The case involved a removal of books from a library, from a school library. 5 books had been removed. One of them was by Kurt Vonnegut's Slaughterhouse 5. The school board said, we're removing it for its vulgar language. And PICO, the plaintiff, was a parent, I think, of some school children, said, no, you're not doing it for its language. You're doing it because you don't like the political views that are expressed in it. And there was some indication from the school board members that that was the case. And my decision said, well, the district court had thrown the case out and said, it's just not a case at all. The library gets to remove whatever they want. And my opinion said, no, they don't get to remove whatever they want. If they're removing it for vulgar language, unsuitable for school kids, that's okay. But if they're removing it for political opinion, that's not okay. And so I said it gets a trial to determine why did the school board remove it. And it never went that far. The library board capitulated and restored the books to the library shelves. That's what that case was about. The other one was the city's effort to end a subsidy to the Brooklyn Museum of Art because there was a painting that was highly controversial and considered vulgar by many people. And so the city wanted to withdraw their subsidy of public funds from the library because of this painting. And as the book recounts, and they said it's not suitable for children. And so I asked the lawyer for the city, I said, is every book in the public library suitable for children? And he said, no. I said, are they next? And grimaced a little at that question. And within a few days, the case went away and the subsidy was renewed.
What I love about the Pico case was the fact that you sent a copy of your opinion to Kurt Vonnegut, and Kurt
I did,
Vonnegut,
yes. I thought he'd be interested, and to my amazement, he answered the letter with a very interesting letter, which I included in the book.
yeah, which is great. That actually brings me to my next point. I loved your um, well, I guess love for sending letters and sending them to people you admire, or just generally just to send letters.
Yeah, I
Uh,
just fire him off. I know. I don't do it all the time, but I have done it on occasion, and they've elicited some very interesting responses.
yeah, the late well, he passed away I think last year. John Le Carre, you sent him a letter. I think you sent one to the Prince or the Queen, or am I
Prince Charles.
Prince Charles?
Yeah.
um, my where does that come from? What makes you sit down and say, you know what, I'm going to write this person a letter?
Just curiosity. There's an issue, and I'm interested in what they're going to say. With the prince, I did it within weeks of the announcement from the palace that Princess Diana had become pregnant. And I wrote him and I said, you know, you have a chance to become not only a very important king, but one of the most famous if you will announce that the child, when born, will succeed to the throne regardless of gender, because at that time it had to be a male heir. And I thought it was time for the Commonwealth to get rid of the gender distinction, which they did 20 years later. I was just a little ahead of my time. But now the child of the king or queen succeeds to the throne, regardless of gender. The Le Carre thing was quite different. I asked him if he had ever considered, or if he had, when he wrote Spial Came In From the Cold, was he aware of the fact that the premise of that novel is the identical premise used by Agatha Christie in Witness for the Prosecution. People have enjoyed them both. They're both very famous movies, but very few people have made the connection of the premise, which is that if you put a witness on the stand who says something is so, but you want the jury to believe the opposite. Now, what you do is, in other words, in witness, the wife of the accused said he did it, but she really wanted him acquitted. So she accused him. She put on a wig and disguised herself and said he did it. And then she arranged for her testimony to be discredited. And the jury said, well, if she's falsely accusing him, he must be innocent. Doesn't follow logically at all, but they acquitted him. Well, Smiley did the same thing in Witness for the Prosecution. He shored up his witness by sending in an agent, Richard Burton in the movie, to accuse him. And then he undid the agent. And so the East Germans said, well, then he must not be a British agent at all. So they're the same premise. And I'd never read anyone making the comparison. So I thought I would ask him. And so he answered.
Do you feel like the art of writing a letter that you have, thought through and probably scrapped a few drafts of before you sent off to somebody you truly admire or respect, or whatever it might be, is a lost art?
Well, in the first place, I don't have time for several drafts. If I write a letter, I write it, put it in an envelope and send it. The only trick with Le Carre was how to get it to him.
Right.
And that's sometimes a problem. So I sent it to his publisher. And I said, I don't know his address, but here's a letter to him. And I'd appreciate it if you forwarded it, if you did. But no, it doesn't take time. And I'm not suggesting I do it frequently. I do it once in a while when an issue comes to mind that I'm curious about, and I'm interested in what the person might say or think.
Mm-hmm. Do you, with the advent of the internet and people using email for most communication, or text, or maybe people still call each other, I'm not sure, but do you think the same way of conveying a message can be uh, shown through email as it is in a letter, or is a letter?
I doubt it. I doubt it. Now, the email, of course, has the great virtue of instant communication. It gets to the person instantly. But I think it is used so widely that if I had a serious question to put to somebody, I would not do it in email. First place, it would be lost in a jumble of hundreds of emails, and they wouldn't even see it. Whereas I think the letter, particularly on letterhead, that right away identifies me. It's not just some crazy person. Hopefully, they'll think that. But I think it carries a little more weight if it's a letterhead than email, which tends to get too easily disregarded.
Okay. I've considered sending my fair share of letters before. Never got around to it. So
Fun to do.
yeah, to maybe begin wrapping up a little bit. What advice would you give to aspiring lawyers and to generally people pursuing a career in whatever direction they see fit? What advice, career advice, would you give people?
I guess the main thing, you heard about people in school. I mean, on their way.
Yeah, maybe out of college or like a couple of years out of college.
Oh, well, I was thinking more in school. I mean, it's almost too late. The preparation has to begin while they're in school.
Mm-hmm.
Main thing to do, if they have any notion of a pursuit of a career in law, is to be very facile at writing. They should write as much as they possibly can. The best course I ever took in high school was a course that required me to write a theme every day for 3 months. It was grueling work for young kids, but it was vital. Best part of my whole education. So writing and paying attention to writing and reading and paying attention to good writing when you read, so that you have first the full understanding of grammar, which unfortunately isn't taught at a lot of schools, and broaden your vocabulary as much as possible, and noting writing styles. I think all that is more important than the substance of anything you learn in school. Once you're out of school, somebody is interested in law school. I don't know. It's hard to give advice. I'm not sure it matters what they actually do in a year or two before law school. I think they should just do things that interest them. I don't think I have anything particular. Write well and read widely. Those are the main things.
Can you, if you didn't spend much time writing in college or high school, can you become a good writer in your 20s?
I don't know the answer to that. There are writing courses. I mean, there's creative writing for those who aspire to write fiction or poetry or things like that. I guess those are of some use, but I really think it needs to begin in the earlier aspects of your education.
Mm-hmm. And to the final two questions I ask of all my guests on the podcast, I'm going to bundle them together and you answer them in any order you see fit. The first one is, what gives you hope for the future? I hope you have some hope. I've had people that have no hope, so I hope you have some. And the second question is, what are 5 books, fiction, nonfiction, whatever you please, that you would recommend to anyone on any topic?
Well, let's start where you ended with the books. Those who enjoy the genre of espionage novels, they should read all of Le Carre, and either start or save for the best Smiley's People, which I think is the greatest spy novel ever written. But Tinker Tailor is probably the second best, and Spy Who Came In From the Cold is the third best. But he's written so many. The ones in the later years are not on a par with the earlier ones, but if you like that genre, you should read them all. If you like good fiction detective stories, there's a novelist by the name of Philip Kerr, Kerr, who died a few years ago. who is one of my favorite mystery writers of detective stories. He has a German detective hero who was working for the Germans in the 30s, but hated the regime, but he was such a great detective that they had to use him. And the books are astonishing because the author imagines conversations between the detective and the leading figures in the Nazi regime, and they're quite fascinating. As far as nonfiction, there's a wonderful book about Hamilton and Jefferson, not the play, but an earlier book. And of course, you mentioned David McCullough. Any of his historical accounts are always worth reading. He's a brilliant historian and a wonderful writer. As far as hope for the future, I guess I'm somewhat optimistic, but it's been dulled a bit by events of the last several years. I think I despair how bitterly divided the country is, how political discourse has become so divisive. That's very unfortunate. When I worked at the Senate, my boss could go talk to a Republican senator. I could go talk to a staffer for a Republican senator and have good conversations and work out bipartisan amendments. That's almost a lost art today, and that's a terrible situation. It's a terrible loss. So I'm very distressed at how polarized the country has become. Whether that will recede, I don't know. I hope so, but I can't say I'm very optimistic about it. I think it depends on the next wave of political leaders who have it within them to not only talk bipartisanship, but to work at it and to try to lower the temperature in the country, the political temperature, and seek common ground where it can be found. If that happens, my sense of optimism will be renewed. But I think the country is going to have some difficult years until that happens.
I just want to say it's the reason I do this podcast is to be able to have conversations, sometimes with people I agree with, sometimes with people that I disagree with. And at the end of the day, I hope that both parties leave with a smile on their face and the feeling of some kind of satisfaction and being able to get to the bottom of some issues that are facing this country and the world. But it's also an opportunity for me to sit down and talk to people I admire and grow personally. I'm 24 years old. I feel like I'm just starting out in my career and my life really. So to be able to speak to a person like yourself and to people like you is a privilege and an honor. And I thank you for coming on to the podcast.
Well, glad to do it. We've had, I think, an interesting conversation, and you're a good interviewer. You ask interesting questions, and I hope I've covered the ground that you hoped I would.
You did. Thank you very much.
Great.